Hello everyone. Welcome to the third panel of Columbia Arbitration Day 2022 on new challenges to investment arbitration, focusing on environmental claims. Those of you who have been with us since morning, I would like to thank you for joining us today and hope it has been an enriching experience so far. And to those who have just joined us, I extend a warm welcome. However, before we begin, there is some brief information for those interested in CLE credits. This panel is accredited for 1.5 credits for areas of professional practice. You will need to submit the attendance form as well as the evaluation form, which are available to download on the Columbia Arbitration Days website and email them to the addresses mentioned there. Please remember to record all attendance verification codes displayed during the program. You will need them to fill the attendance form. You can also review CAD's website to see the instructions regarding CLE credits. We have an amazing set of panelists today, and to make this more interactive, I invite everyone to ask questions in YouTube comment section. This year, because of COVID-19 pandemic, Columbia Arbitration Day is being held virtually. Therefore, we have decided to waive the entire registration fee and make this event free of charge for everyone. However, in light of the current situation in Ukraine and the several ongoing conflicts worldwide, we urge all the participants to make a donation equivalent to our registration fees to any humanitarian international organization of their choice. I would like to now introduce a moderator for this panel, Dr. Kabir Duggal. Dr. Duggal is a lecturer in law at Columbia Law School and is one of the most popular faculty members amongst the students. His rich experience in international investment arbitration, international commercial arbitration, and public international law matters flow from his triple training in international law, common law, and civil law traditions. He's also the managing editor of the journal American Review of International Arbitration and a senior international arbitration advisor at Arnold & Porter. Here is a fun fact about Kabir. Although widely known for his quirky sense of humor, Kabir can also do a headstand and has a diploma for teaching children yoga. Thank you so much for joining us today, Kabir. I would now like to give the floor to him.
Thank you very much, Sakshi. Delighted to be here. Best $100 again this year spent in bribing students to talk good things about me. Before we begin, I would just invite everyone to give a virtual round of applause to our students at Columbia. They work round the clock to make this event happen. It is no small task. It is no small feat. So we really do commend you, for people like me who have to just come and show up and be pretty. That's awesome, because there are people like our students working behind the scenes making this happen. So we take our proverbial hat to you and give a round of applause to you. Well, we're here now, panel 3. And as you can see in front of you, the topic we are going to discuss: new challenges to international arbitration, environmental claims. And let's start at the very beginning. Why are we discussing this? Now, it has been said that in international arbitration, right, counsel, arbitrator, experts, all of us are very concerned about the health and well-being of arbitration. And therefore, we are constantly examining whether any particular practice or policy is ultimately favorable to this goal that we have, the goal of arbitration. And just for the avoidance of any doubts, this very smart person is our very own Professor Berman. He said this in his very famous article, "What Does It Mean to Be Pro-Arbitration?" That's what brings us here today. As practitioners, as counsel, as arbitrators, we are confronted with the challenge of environment. Now, just from this week, right, just this week, we see two realities from two leading newspapers telling us about the environmental threat that we all face. The BBC tells us that climate change has already had an irreversible impact. Sakshi, Simon, this is going to affect you more than it's going to affect the other one of us on the panel. And when you have kids, they're going to be affected even more. Sorry, I know we like to give millennials and post-millennials a hard time, but some of these problems we are leaving to you to figure out. We see a very major, heartbreaking tragedy happening in Ukraine. But like any and every measure, in addition to the deep human suffering, there is also a very severe environmental impact. And that is what I think makes our topic today so important. Everything we do has an impact on the environment, right? And let's think about this for a moment in the investor-state context in particular. The implications of ISDS in relation to the environment is all over the press. It has now entered the public domain. The Economist talks about it, NGOs are talking about it, scholars are talking about it, nonprofits are talking about it. That makes this something we really need to confront, we need to think about, reflecting on what Professor Berman tells us, right? That when we're dealing with challenges, we need to be constantly thinking, are these challenges ultimately helping arbitration, hurting arbitration? If they're hurting arbitration, what do we do? Now, just to give you a little preview, the environment is such a tricky area when it comes to investor-state arbitration. States may want to justify state conduct on the basis that they acted the way they did because of the environment. Investors, on the other hand, may tell you, well, you're saying environment now, but the real reason why you did what you did is because you didn't like me because I'm a foreigner, etc., etc., etc. And then we look at the third player in these dispute, tribunals, who are going to tell you, look, we have limited mandates. We look at the four corners of the treaty. That tells us jurisdiction. That tells us applicable law. Today, you're raising concerns that we don't find within the treaty. What do we do? And just one final thought, the environment may itself become the basis for ISDS claims, right? If you look at the renewable cases involving Spain, Italy, and a lot of Central and Eastern European countries, right? It was the state giving guarantees that in light of crisis and for other reasons they had to rescind, and those have become the basis of ISDS claims. And this gives us the broader point that the environment plays a tricky role. It plays a precarious role. It plays a role that states, tribunals, investors may not be fully certain how to act as a matter of policy. You don't know ultimately where you may end up, right? Now let's just think about this for a moment. Who should try and address the environmental issue? Should it be states, right? They ultimately draft the treaties. Should they be drafting treaties in a more clear manner if they're concerned about the environment? Is that one way to fix it? Should it be the tribunals, right? The tribunals, you can't put everything in a treaty. Situations are going to change, situations are going to develop. Should it be tribunals that use different techniques to try and incorporate international law? Who should be thinking about this? And this takes us to another part of our presentation. This is the time when we would like you, our audiences, to join us for a poll. Now, since the students have done such an awesome job behind the scenes, we thought it's a good idea to let them step forward, get some amount of the screen light to talk about these poll questions. We have 2 S's. We're going to have Sakshi go with poll number 1. Sakshi, unmute yourself and take it away.
Thank you, Kabir. So now we have vote for everyone, and you guys can see the link on your YouTube. So the question that we have for everyone today is, who has the primacy of duty when it comes to protecting the environment in ISDS? Is it the investor, the state, or the tribunal? So there are no right answers. We just want to know your opinion before we move ahead with the presentation. So
we may judge you a little. No, we won't. I'm just kidding.
So
Sakshi, how do people vote?
So there's a link. I think it must be displayed on the YouTube channel. Where
it's in the chat.
Yes.
I'm telling you that. That was a rhetorical point. Sorry. So for people on the phone, just go to your chat. I think if you're on screen on YouTube, it's a little easier. Sakshi, you have promised to do 1 minute of stand-up comedy. This is your time.
I'm really not as funny as you, Kabir. You should take it away.
It's not very good for my credibility or my standing as a future arbitrator when you say my career should be in comedy.
No, that's what made that classes interesting, at least. I mean, we were doing investment arbitration. It sounds so deep. You made it really funny last semester. So that was good.
For all the audience members, this is part of the $100 that I paid Sakshi and Simon before the panel. So take everything they're saying with a big bucket of salt.
Okay, so I think we have our votes now.
Yeah, so count down from 5 to 1 dramatically.
Okay, so we go 5, 4, 3, 2, 1. Okay, let's
go. Can we have the results on the screen, or do you have them, Sakshi?
Yeah, I think I'm just getting them. 1 second. Is it on the screen? Sorry, we've been having some technical glitches. Okay, so 81% people have voted in favor of state.
Okay.
And the tribunal, 13%, and we can do the math. The rest investor is only 4%.
You're asking lawyers to do math. That is very problematic.
So yeah, that's how it is. State 81%, tribunal 13%, and investor 4%.
Okay, so this group definitely feels strongly that the tribunal needs to figure it out. Okay, let's see what our awesome panel has to tell us. Stay tuned for that. But let's move on to our second question. Simon.
Yes, Kabir, thanks very much. So second question, so that you don't feel sleepy after the lunch break, which we all do except Kabir. I'm sometimes asking myself whether he's eating for lunch when I see all your energy. So the ISDS reform process must affirmatively address environmental concern, agree, disagree, or undecided. And I think we can all see that the question has some importance nowadays with the working group 3 being mainly with procedure, of course, but we see that the legitimacy of investment or arbitration and investor-state dispute is at stake, and of course the ability to address environmental concerns in the future might bear on the legitimacy of the whole ISDS process. And I think you should be able to see, as before, the poll in your chat function on YouTube on the right-hand side.
Simon, so you mentioned that the working group 3 is focused on procedure.
Mainly, I think.
Yeah. Would you consider environment to be a procedural matter?
That's a good question. I hope our panelists will tackle it as well. I would argue that it's not purely a procedural question, but there is at least there is probably some way, and I see that the poll is now available on your chat on the right hand side on YouTube. I think there is at least some procedural instrument and mechanism could probably be put in place and then used in a way to enhance to increase or to make environmental issues addressed in a more efficient way. But I think there is also pretty much a substantive issues to be dealt with here.
Let's hear what this awesome panel has to tell us, as you said, but I like the way you framed the issue. Simon, do you think this is a good time to start the countdown?
Yeah, I think it's a good time. Do I have to be dramatic as well? Because
yes,
I'm very, as a Swiss, I'm very bad at that. I mean,
this is where we challenge all our cultural upbringing.
Even though we abandoned our neutrality, apparently I'm very good at being dramatic, but let's try it. So 5, 4, 3, 2, 1, and the poll is closed. And we'll see, I think, the results in a few seconds in the chat in our left-hand side, the right-hand side. Yeah, here they are. So we see 87% of people that agree, 12% are undecided, and 0% disagree. There is one person missing somewhere, but yeah, we see that mainly people agree, and the few that do not agree are undecided. Nobody disagrees. So I think the answers to the poll seems pretty clear, Kabir. The state has to take care of the environment, and the ISDS reform process has to tackle that as well.
This is awesome because I think our panel is going to be talking about these issues, and so we'll get some insights as to what they think the reality is. But thank you both so much for that. And folks, it's my distinct honor right now to introduce, I'm only going to tell their name, probably just their name, because they are all legends. Google them. They're highly Googleable. But if we start talking about them, I fear we will be here till the end of Columbia Arbitration Day, because we truly have put together an outstanding, spectacular, awesome panel to talk to us about this. Now, the way we have set this up is that we're going to have our 3 speakers give us brief introductory remarks for a few minutes. Each of them is speaking on a different topic. We're going to have Yasmine Lahlou. Yasmine's office is behind mine. We meet up all over the world except in New York. This is one of the fun things about our international practice. Yasmine's going to talk to us about why we are here, why we are talking about this issue. She's going to do this stage setting. She's going to tell how these 2 areas of law, the environmental law, and ISDS interact with each other. Very much looking forward to this. We're then going to hear Christophe, who joins us from Europe, talk to us about what our audience see as the most important stakeholder in this game, states and ISDS. How do states and ISDS in relation to environmental claims interact with one another? What are the kinds of issues that come up? And last but not least, we're going to have fellow Columbia alum Matt Draper talk to us about what states are doing today. Are we seeing things getting better? Are states cognizant about this? What new efforts do we see in front of us? We really do have awesome people in front of us. Super looking forward. I'm going to stop sharing my screen now to hear these panelists talk about this. Let me just stop sharing my screen so you don't see something I don't want people to see. Okay, awesome. Yeah. With that, let me pass it over to Yasmine. After this, we will have a little bit of question and answer and discussion among ourselves. But let's hear this awesome panel. Yasmine, take it away. The floor is yours.
Good afternoon, Kabir. Thank you for this dynamic introduction, and you are indeed pretty. The students did a great job. Good afternoon, good evening to our audience in the US, in Europe, and I hope in Europe you have already a glass of wine in hand if you have decided to stick around. Environmental issues in investment arbitration. Well, that's a very broad topic. For us New Yorkers, we have been following the Lago Agrio saga, which has been unfolding before New York federal judges for over 2 decades, though it started many decades ago with pollution in the Ecuadorian Amazon and ended up with a major investor-state component. The long-running dispute has its origin in the Amazon oil concession in the Oriente region of Ecuador that Texaco, now owned by Chevron, operated between 1964 and 1992 as a minority partner with state-owned Petroecuador. A group of indigenous Ecuadorian plaintiffs sued Texaco in New York in 1993 for pollution and environmental-related harm arising from allegedly Texaco's past operations. They tried that without success before going to the local court in Lago Agrio. That happened because Texaco was able to get a forum non-convenience dismissal on the ground that the Ecuadorian court was the better forum for this environmental dispute. The plaintiffs eventually won a judgment in 2011 holding Chevron responsible for environmental pollution, and the judgment was originally at $18 billion, though that was later reduced, but ultimately upheld by the courts, by the country's highest courts. Because the state, Ecuador, had signed a release with Texaco in 1992, and after there had been an environmental cleanup, and which should therefore have precluded the litigation. And because of allegations that the Ecuadorian judge that issued that $18 billion judgment was corrupt and allowed his judgment to be ghostwritten by the plaintiff's counsel, Chevron filed a BIT claim in 2009 against Ecuador, to which it later added a claim for denial of justice due to that judgment, and that judgment being upheld by higher courts. In the meantime, in 2014, Chevron came to New York and obtained a ruling from the US District Court concluding that the foreign judgment was the product of fraud and should be unenforceable in the United States. Going full circle, coming back to New York. An interesting development for international law practitioners and litigators is that Chevron had even sought and originally obtained an order enjoining the foreign international enforcement of the Ecuadorian judgment. That was reversed on appeal, but that was a very interesting analysis by Judge Kaplan, which I invite you to read because it's interesting. Ultimately, in 2018, a tribunal administered by the Permanent Court of Arbitration in The Hague upheld the claims by Chevron and Texaco Petroleum that Ecuador committed a denial of justice under customary international law and the US-Ecuador BIT. The tribunal found that by issuing, rendering enforceable, and executing the Lago Agrio judgment and knowingly facilitating its enforcement outside Ecuador, the state had wrongfully committed a denial of justice for which it is liable to make full reparation. This dispute is not completely over, as a portion of the lawsuit remains in the New York federal courts between Chevron and the plaintiffs' U.S. counsel, Stephen Donziger, and we all follow this saga with interest. Another relevant related facet of the confluence between the environment and investment arbitration are cases having their origin in a fiscal or regulatory regime favoring renewable energy, which was later revoked, in part or in whole. Those are the claims by investors who had made investments in the renewable energy sector and sought compensation when the host states, generally in the aftermath of the 2008 financial crisis, revoked financial fiscal regimes and subsidies. We have seen a huge number of such cases going many ways, with jurisdiction being denied in part on the Achmea theory, upholding the claims in whole or in part. But those arbitrations were not really about the environment. Other cases, such as Vattenfall against Germany, which had been lodged in 2012, was based on allegations that Germany had violated the Energy Charter Treaty when it decided to accelerate the phase out of nuclear power production in the aftermath of the March 2011 Fukushima disaster in Japan. The case settled just a few months ago in November 2021. And again, this was not really a case about the environment. In its recent order, the tribunal observed that it had become clear that the tribunal issued an order to close the case after the settlement. And he said it became clear that it's not a case about the question whether Germany should or should not have nuclear power plants. Rather, this case is about whether owners of nuclear power plants should receive compensation for shutting down plants prior to the end of their economic life, once a democratic decision has been made to end nuclear power generation. A lot has been said, good, bad, ugly, about investment arbitration. Perhaps because of those criticisms, or at a minimum, the debate's liveliness, one remarkable feature has been the law's ability to react and progress in a very concrete way that few other areas of international law have achieved. It's a tautology, but the source of law in investment arbitration is first and foremost the bilateral investment treaty and other investment agreements signed by the states. And for many years, as states and others deplored that the system was skewed towards investors, with the tribunals offering overly broad interpretations of the investor protection mechanism, the response was, wait, you states set the rules and have the control to state explicitly in the treaties what these agreements should mean. And that they did. The dynamics created by the endless number of arbitrations started and awards made gave the momentum to de-ossify investment law and make the language of BITs responsive to their times and rectify any actual or perceived imperfect balance between the rights of the investor and the privileges of the state. Lawyers in ministries, delegates at the UNCITRAL working group, institutions, nonprofits have been actively reframing the investment arbitration regime to rebalance some perceived excesses and injustices. And in doing so, as discussed today by Professor Kaufmann-Kohler, restore some legitimacy and fairness to the system. In that, we should acknowledge the role of schools and LLM program all over the world, from Stockholm to Singapore, and that, of course, of Columbia Law School and Professor Berman in particular, which have trained a continuously growing number of arbitration practitioners, some of whom went home to government jobs to revisit and revive their state's BITs and revamp their government practices and procedures handling foreign investors and documenting those new practices and procedures. In that, I obviously accept the inevitable, and always so pleasant Brazilian LLM contingent in Colombia or at NYU, whose country has remained blissfully immune to the BIT frenzy. We call it here the Copacabana immunity. And aside from some gimmicky initiatives, the progressive importance of environmental considerations in BITs and the world has been one of the most remarkable examples of a slow start followed by an incredible acceleration and dynamism of the law in the past years. As most things in international law investment arbitration, the discussion starts with the treaty. Historically, the emergence and form of environmental issues in ISDS followed the world's slow but gradual awakening to the significance and critical importance of environmental issues in the state's regulatory apparatus and policy priorities. As international law was catching up to rebalancing economic development and promoting international trade and foreign investment with later the protection of the environment, that balancing process began. And as a result, when measuring the legality of the conduct of the host state investment tribunal, for the most part, originally lacked the tools or the imagination to properly take into account and enforce the importance of environmental dimension of certain regulatory measures, which remained in relative indifference in the ISDS regime. What I mean is that the relevant treaties, which are the source of jurisdiction and the primary source of law applied by investment tribunal, did not give much room, or were not interpreted to give much room to account for the environmental aspects of measures when assessing when the state's measure could fit the BITs or the investment agreement framework. The law has developed slowly, and even though we told way back that precedent is normally inapplicable in international arbitration, and this is not at all the case in investment arbitration. As such, so long as the most brilliant minds have not had the clarity or the courage of offering and applying novel reading of the law or of treaties, we remain stuck in very narrow inclusion of environmental concerns in investment arbitration. And an example is the Metalclad award investment issued in 2000, an NAFTA award involving industrial waste facility, hazardous waste site in Mexico. And there, NAFTA provides, Article 11.14, that nothing in this chapter shall be construed to prevent from adopting, maintaining, or enforcing any measures otherwise consistent with this chapter, which protects the investment, that it considers appropriate to ensure that investment activity in its territory is undertaken in a manner sensitive to environmental concerns. If you read the award, the tribunal really paid lip service to that provision, though it acknowledged that Mexico has the power to ensure that investment complied with environmental obligations. But in the tribunal's reading, that provision permits a party to ensure that investment activity is undertaken in a manner sensitive to environmental concerns. It is interesting because at the time, in 2000, a journalist from IA Reporter said Article 11.14 is phrased as a tautology, allowing environmental measures that are otherwise consistent with Chapter 11, and noted that as a result of sort of this hierarchy of norms, this reverse hierarchy of norms, in subsequent cases, tribunals have rarely offered much of a foothold for government for seeking to involve the defense of investment environmental mismanagement. And the author was right. It was only 18 years later, in the Aven against Costa Rica, that the tribunal interpreted identical provision in the DR CAFTA to find that imposed treaty obligation on investors. And that could also be the source of a cause of action against the investor by the state if a counterclaims were available. And so because of the hesitancy of tribunals to read implied or expanded environmental obligations on investors, international negotiators caught up by changing the language of treaties and implementing explicit language into treaties. I will stop here because I do not want to steal Matt's thunder as he will address the changing treaty landscape. But how, even with the relevant treaty language and an open-minded tribunal, how can the state assert its claims, not only that its measures were justified by domestic international environmental obligations, but get some redress for the investor's conduct that's harmful to the environment? Historically, states have alleged environmental violations as a defense, especially in the mining context, and it is becoming increasingly common for states to try to use these violations as counterclaims. I will not say more on that topic because Christophe will tell us about sort of what procedural framework and hook is there for the enforcement of environmental rules and measures. I think I'm running a little late in time, so I will spare you the statistics, except that people who have studied the numbers have seen a slow growth of environmental related arbitration after the 1990s, probably after the 92 Earth summit in Rio back to Copacabana, and then a real increase after the 2010. And as of 2016, some Flavia Marisi had seen that there were between 2012 and 2015 about 65 cases pending involving environmental issues. A few concluding remarks on this section. Investment arbitration is about providing a forum for protection of investments and investors. This is what the tribunal's order in Vattenfall reaffirmed. Except that international investment and law in arbitration has never been about curtailing the state's legitimate exercise of its authority to act and protect the environment or implement other key priorities. This rebalancing exercise, perceived by some as necessary, has been one of the remarkable developments of international investment law of the past decades. But the investment law is about the protection of the investment, and there are probably other fora to actually enforce outside the context of a specific investment environmental measures. One last point about sort of investment agreements and the public interest. A large number of disputes are really outside the typical investment protection system, as we have been discussing, because they are under concession agreements between the investor and the state, which may provide for arbitration outside the typical investment protection fora and outside bilateral investment treaties. And it is often the terms of those contracts which often incorporate CSR standards and domestic law, not the BITs, that are the main source of the investor's environmental duties and limitations. And I'm sure Christophe will tell us about it, but Burlington and Ecuador, or against Ecuador, involved some counterclaims, which were based not on a BIT, but based on the agreement between the investors and the state. Thank you very much. And I'm sorry for taking a little longer than I should have.
No, not at all, Yasmine. That is great. You've done such an awesome job. So many issues you raised, the complexity of forums, the complexity of what is environment, how are these alleged, what are the defenses. You've really done an awesome job, so thank you for that. Christophe, 83% of the audience think states have to fix it.
Yes, well,
why?
well, I think there's some good reasons for that. Good afternoon, everyone, and thank you, Kabir, for the kind introduction. So as you heard, the topic I'll be covering is specific ways in which states have relied on environmental issues in investor-state dispute settlement. And I'd like to take a step back and look at the different manners in which environmental law issues may surface and are increasingly surfacing in investment arbitration proceedings. So the traditional scenario is where a state has taken measures, whether they be legislative or regulatory decrees or cancellation of contracts, that purport to be for environmental reasons. In this scenario, the state invokes the environmental issue as a defense to an investment claim. In some instances, this has been successful, and in others, as Yasmine has shown, it hasn't. Sometimes the tribunal has concluded that the intent behind the measure was in fact discriminatory and not truly for environmental purposes. In the second scenario, the state invokes environmental issues offensively. In this situation, the state may try to bring a counterclaim against the investor for harm to the environment in connection with the investment. This is difficult, though, because depending on whether the language of the arbitration clause in the BIT is broad or restrictive, and leaving aside contractual disputes arising under an umbrella clause, BITs usually don't allow for counterclaims by the state, and there's a fundamental question as to whether the tribunal even has jurisdiction over such a claim. The third scenario is a bit of a hybrid. The state uses the environmental issue as both a sword and a shield. When faced by a claim by a foreign investor that harmed the environment in the course of making or operating its investment, instead of raising a counterclaim, the state could argue that the investor did not make its investment in accordance with the law and that the tribunal does not have jurisdiction to hear the claims or that the claims are inadmissible. I'd like to focus on the last scenario, as unfortunately I don't have time to cover all three. So when an investor brings claims against a state because an international investment arbitration tribunal, before an international investment tribunal, and where the state alleges that the investor has harmed the environment in connection with its investment activities, the tribunal may assess the lawfulness of the foreign investor's conduct. Violations of environmental law are, of course, contrary to the domestic law of the host state. And BITs often contain a legality requirement. In other words, a requirement that the investment has been acquired and even operated in accordance with the domestic laws of the host state. Therefore, where the foreign investor committed environmental law violations in connection with its business activity, arguably, it did not establish or operate its investment in accordance with the host state's laws. The host state might raise this argument even if the treaty does not contain a legality requirement, since some tribunals, including the UCOS, Plama versus Bulgaria, and Phoenix Action versus Czech Republic tribunals, have held that this requirement is implicit. Commentators and jurisprudence are, of course, split regarding the appropriate scope to be accorded to these legality clauses, some favoring broad and some favoring narrow approaches. It's useful to look at two cases where this legality requirement was raised in relation to corporate social responsibility issues. In Cortec Mining Kenya Limited versus Kenya, the tribunal confirmed that the environmental impact assessment study was one of the requirements of a lawful investment in accordance with Kenyan law. The claimant had obtained a license, which, while validly issued, did not entitle it to mine or extract minerals. The license had several conditions precedent to the valid issuance of a mining license, one of which was the requirement to perform an environmental impact assessment study, or EIA. The tribunal found that these preconditions were imposed by the Kenyan Mining Act and other regulations and had to be satisfied by the claimants to receive a valid mining license, and that, quote, no amount of frustration with the bureaucracy excused the claimant from non-performance of these legal conditions. The tribunal went on to find that the claimants had failed to comply with the mandatory preconditions, including conducting the EIA study. However, the claimants applied for a mining license despite not fulfilling these conditions and obtained it after engaging an intermediary who met with the Commissioner of Mines. The tribunal found that this sequence of events constituted a circumvention of the applicable legal requirements and dismissed claims on account of a failure to obtain a valid EIA license. The tribunal found that the failure to comply with the environmental regulatory regime warranted a denial of treaty protection. In Copper Mesa versus Ecuador, the claimant engaged private security forces to attack local opponents to a mining project. The respondent argued that the claimant had thus violated corporate social responsibility principles and international public policy. Because of this, according to the respondent, the tribunal either lacked jurisdiction or the claimant's claims were inadmissible due to unclean hands. The tribunal ultimately did not directly address these arguments, since it held that the legality clause of the BIT was limited to the time of acquisition of the investment, and thus the claimant's subsequent conduct was irrelevant in that regard. It also rejected the unclean hands argument, finding that Ecuador was precluded from raising the argument because state authorities had been aware of the investor's misconduct at the time and yet did not complain. This would suggest that had the state authorities complained at the time, the tribunal might have found these claims inadmissible. However, the tribunal took into account the respondent's allegations of claimant misconduct at the merits phase to find contributory negligence on the part of the investor. It observed, quote, a foreign investor should not resort to recruiting and using armed men, firing guns, and spraying mace at civilians, not as an accidental or isolated incident, but as part of a premeditated, disguised, and well-funded plan to take the law into its own hands. And the tribunal accordingly reduced the claimant's compensation by 30%. In both of these cases, the tribunal examined the legality requirement at the making of the investment. In Cortec, that examination was sufficient to dismiss the claims. In Copper Mesa, while the tribunal admitted the claims, it nevertheless took the violation of corporate social responsibility principles into account when assessing liability, in effect punishing Copper Mesa for bad behavior. These two cases show different ways that tribunals may give effect to environmental regulations in the context of ISDS. However, more recent BITs have imposed requirements on investors to not only make the investment in accordance with the law, but to operate them in accordance with the law. A prime example of this is the Morocco-Nigeria BIT, which provides in Article 18 for post-establishment obligations, which include that companies in the area of resource exploitation and high-risk industrial enterprises shall maintain a current certification to ISO 14001 or an equivalent environmental management standard. So as an aside, I just have to say that in regards to environmental protection, that BIT is just extraordinary. It's clearly drafted with the extractive industries in mind. It has an entire article dedicated to environmental impact assessment, Article 14, which provides that investments must comply with environmental assessment screening prior to their establishment, and that both investors and host state authorities shall apply the precautionary principle to their environmental impact assessment and to decisions taken in relation to the proposed investment. I don't know if there's a BIT out there that provides a more robust environmental protection than this one, but I would certainly love to see it. So as we saw, if a tribunal finds that a foreign investor committed environmental law violations that were contrary to domestic law, it may conclude that it does not have jurisdiction over claims and or that the claims are inadmissible. So in conclusion, insofar as tribunals have declined jurisdiction over claims or deemed inadmissible claims where the investor had unclean hands due to acts of bribery, corruption, or fraud, arguably a fortiori, they may be called upon to do so when the investor has unclean hands due to environmental law abuses committed in connection with its investment. But tribunals might also take into account environmental law violations at the merits and or quantum stages of the dispute. For instance, they may take into account the corporate social responsibility standards and codes when assessing whether an investor did proper due diligence in connection with its planned investment. Should it have done? Did it do an EIA? Such determinations could affect a tribunal's finding with regard to the investor's legitimate expectations. So I've kept it short. That concludes the presentation, but I'm happy to talk further about treatment of environmental issues in ISDS cases and to comment on principles of, the principle of precaution, margin of appreciation, right to regulate, or the tribunal's obligation to defer to state decisions.
Thank you so much, Christophe. Again, these are very complicated issues, and we're very grateful to you, to Yasmine, because you all have so nicely laid them all out in a manner that we can see the complexity and the different ways in which these two areas interact, the role of states. And that takes us to our next topic, Matthew. What are states doing? What is happening in the world? Please take it away.
Thanks, Kabir, and want to thank you for this, for putting this panel together, and to the hardworking Columbia students who, I have no idea how I would have put on a Columbia Arbitration Day while also studying at Columbia at the same time. So I'm amazed by you and your capacity to do amazing things. So congratulations. As a preliminary, I just wanted to say that I'm very disappointed we're not meeting in person. However, there is one consolation to not meeting in person. Is the last time I did something like this, Kabir put my photo, blew it up on like a 50-foot tall screen in front of everyone. And, you know, having to look at yourself in that magnitude for more than you know, a second is very humbling, and I'm glad I didn't have to do it today. Yasmine and Christophe, excellent presentations, tough acts to follow, and you know, touched on a number of the issues that I wanted to talk about too, and that's for good reason, in that it really is governments who are in the driver's seat in terms of defining what sort of investor protections are going to be applied in their jurisdictions. And so they rightly were talking about a number of the things that I will too. But I just want to step back a little bit. There's intense pressure to reform the investor-state dispute process. And part of that is problems with the process. And part of that is problems with or frustrations with the substance and the outcomes. And I would suggest that that frustration is only going to rise for a number of reasons. One is that, you know, there's a massive transition going on right now toward away from fossil fuels and towards investments in societies that have to live with a world with climate change. And so we're seeing a lot of investment activity around this. States want to attract investments related to this. And so they want to have attractive investment environments. And at the same time, states are having to take actions to meet their climate change goals, reduce greenhouse gases, and change the regulations. And so that's leading to disruptions in the environment in which these investments are made. And as we all know, change is good for lawyers and generates disputes. So, and all that is to say that if the ISDS system is under a great deal of scrutiny and attack right now, because there's this impression that it is preventing governments from doing what they need to do to protect their citizens in a variety of ways, including in environment and climate change. And so there's a real urgency to the reform and change that's going on here, because if it doesn't happen soon enough, that frustration could build and lead to a total change in the way that countries approach investment protections and resolve disputes. And you know, you know, there's a lot of benefits to the existing system, even though there's a lot of problems with it. And so there's a danger of losing all of that. Okay, so and you know, one great example of this right now that's playing out, we've had a couple of cases brought in the last 12 months that reflect this, but I would expect dozens, if not hundreds of more cases in the coming years that follow this fact pattern, where the Netherlands, in this case, has been found to be, by its Supreme Court, to be failing to meet its climate change obligations. It has passed so it's under judicial order to improve that. Part of its efforts to do that is to phase out fossil fuels, coal. It's doing that. And in the last 12 months, it's been sued by two investors in the coal industry in the Netherlands for effectively depriving them of the value of these investments in coal-fired power plants, which, as we all know, take a generation to pay off, and so you have these stranded assets, and who's going to bear the loss? Who's going to be left holding the bag when I think there's broad agreement that we need to move away from producing so much greenhouse gases, but who's going to pay? The government, these investors, and that's really what the fight is over. One problem, and I think this complexity came out in Yasmine and Christophe's presentations, there is no, one problem with talking about this topic at all is that there is no such thing as a unified global law of foreign investment. It depends on the treaties that provide those protections and that provide the avenues for vindicating those protections. It really is a case-by-case basis, and this leads to some of the frustration, right, by environmental groups and others who say, well, this tribunal found that there was no expropriation when there was this environmental regulation was put into place, and yet this tribunal on the other side found that there was. That's outrageous. And it may be there's every case is different, and maybe there's bias but the first place I would look is the text of the treaty that was being applied and the facts in the underlying case. And in every one of these cases, there are differences, and so those differences matter. And that's going to be the focus of my talk here: is what are states putting into their treaties that affect investor protections. It cannot be doubted that in the environment, the right to the authority to regulate societies to protect the environment, and more recently to forestall climate change, was a major blind spot for the drafters of investment treaties a generation ago. It was just not on their radar. And so a lot of the cases, including some of the cases that have been discussed here today, involve the application of treaties that were not designed. Maybe there was a reference to the term environment in a preamble, or but that was not a major focus of these treaties that came in in the large part in the 70s, 80s, and 90s. That's begun to change recently, so let me talk about that. And Yasmine referenced this. She talked about how sort of there's been this slow recognition that's then accelerated and affected things. And this is borne out if you and people have done this, looking at the treaty. So there's an OECD study from about 10 years ago where they surveyed over 1,600 international investment agreements. Only 6.5% refer to environmental concerns. And mostly those were FTAs, not BITs. Okay, so and those legacy treaties, most of them are still around. They have not been reformed. They haven't been superseded. And so imagine the frustration that's going to occur if some claim is brought under those old treaties, which are, I can do the math, but over 93% of them, don't even contemplate the environment. So that relies on the tribunal imputing meaning that was not explicitly there if they're going to vindicate some sort of environmental interest. And this number, even that number, which is shocking to me, doesn't really fully capture the the lack of attention to the environment, because there's different ways to refer to it. Many of these treaties say something nice about the environment in their preamble, but nowhere else. That is rarely, if ever, found to be an enforceable right by tribunals. And then, and one step better than that are provisions that recognize the duty of the state to enforce and promote environmental protections. Those are nice, but I don't think their primary goal wasn't necessarily to create a like a environmental counterclaim right for the state. Rather, it was to indicate that the states were not going to engage in some sort of race to the bottom to attract an investment. So those kind of provisions don't provide much protection once a dispute has arisen. The more so among this sort of 7% of bits that address it, the more effective one, and the ones that you see being applied in favor of environmental considerations by tribunals, expressly preserve the right of the state to regulate environmental matters. You know, a typical provision like this would say, nothing in this chapter shall be construed to prevent a party from adopting any measure otherwise consistent with this chapter that it considers appropriate to ensure investments occur in a manner sensitive to environmental concerns. Okay. So that's pretty good. But for a number of tribunals, it's not good enough. For some, it is, and so this is we're getting closer to an enforceable right, and depending on the circumstances, and depending, some might argue, on the tribunal. What a provision like that leaves open is, okay, that sort of regulation is a legitimate form of regulation, but who pays? Who pays for the costs of changing the regulatory framework to prohibit a certain activity, or to curtail it, or make it more expensive through having to abide by, you know, certain environmental requirements? And that is not a settled issue, and there are tribunals that have come down on both sides of that issue. Some have said that's a risk that the investor bore, and some have said no, go ahead, regulate as much as you want, but you have to compensate the investors whose investments are diminished by that regulation. So there's a lot of areas to talk about here. I'm going to focus on one form of provisions that is becoming increasingly popular in treaties. But this is a very rich topic. I mean, you could just focus on procedural issues, for example, like the right to bring any sort of counterclaim, which could include an environmental counterclaim. I mean, that's you know, most of these treaties do not permit, or have been interpreted as not permitting, a counterclaim by the state. So you know, what do you do with that? Hopefully you can deal with it as a defense, as Christophe mentioned, but it doesn't always fit so neatly like that. But anyway, those are all the things I'm not going to talk about, among other things. So you know, in my view, a way forward that I think would be quite successful, and is to don't put the tribunal in the position of asserting value judgments as to whether a particular regulation is is a good idea or a bad idea, or that the state's objectives are legitimate or not legitimate. That creates a mess, and that is, and there's a lot of instances of that really coming down to value judgments. If you look at so this emerged in the 2012 model bit of the US model bit, this provision. Non-discriminatory regulatory actions by a party that are designed and applied to protect legitimate public welfare objectives, such as the environment, do not constitute indirect expropriations. They just come out and say it. They don't say that it's a factor that should be considered. They just say this is not, cannot be considered an indirect expropriation. That just takes it off the table. This approach has been widely adopted in the last 10 years by new treaties. The old treaties are still the same, but you see almost identical language in diverse treaties from around the world. There's the 2018 Singapore Rwanda, 2017 Hong Kong ASEAN investment agreement. They adopt very similar language, protecting the government's, the state's right to regulate in those areas and to avoid indirect expropriation claims on that basis. I would agree with Christophe, however, that the state of the art right now is the Morocco-Nigeria bit that he discussed earlier. As Christophe has already explained, it takes a very sophisticated approach to ensuring that the state can regulate the environment in relation to investments, and it does this. So this is an approach that would be in addition to the one I just described that appeared in the 2012 U.S. model bit, but it addresses or it requires that there be environmental impact assessments, and that those assessments must be complied with, and that they are defined, what their requirements are defined by local law. And so the nice thing about that is that every time you identify, right now we've identified climate change, 30 years from now, there's going to be some other disaster, or I hope not, but there might be some new environmental disaster that we can't imagine right now. But this kind of provision permits the state to change what the content of those assessments are over time, and an investor cannot claim all other things being equal, can't claim that it's entitled to a certain type of environmental assessment, and so it gives the government a way to adjust its environmental regulatory structure as new things arise. And I mean, one thing I would say, Christophe mentioned this, that it even references ISO 14000 standard. I think that's overly prescriptive. 40 years from now, we're going to be at ISO 14 million or something, and so then this bit, which is sort of state of the art now, will seem like a relic and be outdated and may cause trouble. There's more to be said, but maybe I'll end there. But I think it's nice to hear that other people agree with me that these sort of more sophisticated approaches to environmental impact assessments, which are very new, to be explicitly referenced in treaties, is really the way to go. With that, I'll end.
Thank you so much, Matt. And can I invite everybody in the audience, as Yasmine mentioned, especially the Europeans, to raise their glasses, for everyone in the Americas, just to give a round of applause to these awesome panelists. We're talking about a topic that has so much nuance. You can do a whole panel, a whole day with panels just talking about the environment. So thank you for really, I think, taking one of the most difficult issues and trying to address it with the sophistication that you did. I have the fun task now of asking these panelists very tough questions, but I'm greatly assisted by our awesome audience who have been sending us great, tough questions. I have the fun task of picking from our panel my favorite kids and asking them different questions. So that's exactly what I'm going to do. But let's make it more difficult for our panel. We'll urge our panelists to try to give us responses within 2 minutes. Let's see how well they can do this. Yasmine, first question for you. We've been talking about this binary relationship, investor and state, right? But there is the public interest, there is the public at large that may also get implicated by these disputes, right? Especially when we're talking about the environment. And this is the question from our audience, what role should the amici, I don't know how you exactly pronounce that, amicus play in these disputes when it comes to environmental issues? And if you think that they should play a role, how effective do you think they are? Yasmine, take it away.
If you're talking about your friends, it's amici, but I think in this context, you're amicus amici. I think a key point is what role and how effective are amici in international investment arbitration. As you said, this is necessitated by the public interest nature of this of some of the issues raised by investment arbitration. Not the whole dispute, but some of them. And the role is largely a function of the substantive condition that are imposed by the arbitration rules or the BITs as they have been interpreted by the tribunal, who still retain great discretion on the admissibility of amici. The most critical one is the utility of the brief in assisting the tribunal. That is really which really means offering a different perspective on the dispute. The amicus is not a participant in the arbitration and represents an interest that is different from that of the parties. So that really you should offer something that none of the parties have offered. And it's reflected in Rule 37.2 of ICSID, UNCIT rule, etc. One example is the Glamis Gold decision, 2005 UNCIT rule award, in which the tribunal, based on the NAFTA FTC statement, accepted submissions by the Quechan Indian nation, who could be affected by the outcome of the tribunal's decision and would have, but for the participation through amicus submission, no access to the tribunal. And in addition to being related to the dispute, the participant must have an interest in the arbitral proceedings. And this is generally more specific, much more narrow than a general interest. Otherwise, we'd all be filing in amici every day. And really, the UNCIT rules speak of a significant interest. The SIAC rules speak of a sufficient interest. And Infinito Gold, Costa Rica, an ICSID decision from 2016, the tribunal had confirmed the significant interest of an NGO in the proceedings because it had been successful in a domestic litigation against both the investor and Costa Rica, and which had resulted in the revocation of the mining concession. So that's really the role that amici should play, giving the perspective that no one else is bringing to the arbitration by people who are directly affected and interested by the dispute. How effective are they? Well, I guess the amicus is as good as its author, and in some they have been welcomed, useful, and effective, and in others they have not. And I think I can invite you to read an article that I found by Eric de Bond on amicus curiae, published in 2018, and part of the Max Planck Encyclopedia of International Procedural Law. And he notes that even though the number of applications to submit amici has exploded, really the number of those being admitted and being cited in award is comparatively minimal. And because even when the tribunals let in the submissions, they rarely refer to them. But Eric de Brabander noted an exception, for example, in Bywater Gulf versus Tanzania, the 2008 ICSID award. The tribunal actually reproduced some of the submissions from the amici and found them useful, since the brief had, quote, informed the analysis of claims. They have also done so in the case of the European Commission, because clearly it's raising a critical, important jurisdictional enlightenment on the critical jurisdictional aspect of the dispute. You have in Philip Morris against Uruguay, again the World Health Organization was submitted something, and I think that the tribunal cited to them. So this reflection that took me back to a discussion you and I had, Kabir, like I think Monday, about tribunal and appointing their own experts to assess certain issues that have not been addressed by the parties, and I think the practice of international arbitration has become such that it's very rare and very unusual for a tribunal to take that initiative and raise on its own some issues that have not been addressed by the parties, or investigate some issues that have not been investigated by the parties. Amicus basically indirectly play that role, where they offer an expert's view that are permitted by the rules, and without the tribunal having to agonize what to do and whether to exercise their discretion authority to seek additional views on questions that they really want to ask but they don't know how to.
Thank you, Yasmine. That's awesome. Christophe, states should draft better treaties. States should put in explicit language. States should say what they mean, right? This is what we have always tried to address and advise states, right? Do a better job, make your language better. Does the language actually make a difference? And I want to direct the attention to this case that came out last year, Eco Oro versus Colombia, which, that case was fascinating because there was a general exception clause, but the tribunal seemed to suggest that the general exception didn't exclude possibilities for compensation.
Yes. So I mean, the issue is fascinating, and I think I would preface the discussion by saying, obviously, it would be it would be greatly to the tribunal's assistance if states were stated expressly exactly what they intend with respect to some of these environmental issues. And certainly, I think it would also clarify the situation for investors. There's one aspect here that I think we can't forget about, though, is that when you change a regulatory environment for an investor, and you have to look at it also from a business perspective, is what investors do is they will, for any investment, assess the risk. And if they consider that the cost benefit analysis is worth it, they'll go ahead and put money. But oftentimes they build in risk factors into their economic assessment. And if we're telling now investors, okay, look, if there is an environmental regulatory change, you, investor, are going to bear the risk of this. We should be prepared to either see a decrease in the level of investments, or investors demanding a greater economic returns to account for that risk. So just as a policy point, I think we can't forget that when there's action, there's reaction. In terms of the specifics of your question, certainly some states may have been caught by surprise where they thought they put forward fairly clear provisions, and in fact, it turns out that tribunals have disagreed with them. And as you mentioned, Eco Oro is arguably one of those. And I'm going to try to summarize it rather quickly. It's a fairly large award, but here goes. So Eco Oro entered into a concession contract with the Colombian state entity that gave it exploration rights as well as a conditional right to exploit minerals. The problem was that the concession area overlapped with a wetland, and this overlap became a primary issue in the case. And what happened was that the state, which was really faced with conflicting priorities, wanted to develop, make the area attract investment, get the infrastructure, but at the same time, it had this ecological imperative to protect wetlands. Let's say, for a better word, waffled, and was less than diligent in determining what the specific contours were and this overlap between the wetland and the concession itself. In the end, the final delimitation was made, and over 50% of the investor's concession had an overlap on the wetland, and then the investor initiated arbitration. And to defend its actions, Colombia relied on the general exceptions clause under the Canada-Colombia FTA, specifically Article 2201-3, and which provides inter alia that nothing in the agreement should be construed to prevent a party from adopting or enforcing environmental measures. And Colombia argued that because the general exception regarding environmental measures applied, there can be no violation of the FTA and thus no state liability, and consequently, payment of compensation would not be required. The tribunal did not accept the interpretation and concluded that while a state may adopt or enforce environmental measures without finding itself in breach of the FTA, that doesn't prevent the investor from claiming under the investment chapter that such a measure entitles it to payment of compensation. In other words, even if a state is not liable under the FTA, they can still be liable for a breach of the FTA, excuse me, they can still be liable for compensation. And the tribunal was split on the issue. It was a tribunal consisting of Ms. Juliette Blanche and Professors Horacio Griguera Naon and Professor Philip Sands. And the majority, which was composed of Blanche and Sands, held that Colombia's actions did not amount to an indirect expropriation, emphasizing that the state's measures were non-discriminatory, pursued a genuine public welfare objective, and were in good faith, and were designed to protect the environment. But a different majority, which was composed of Blanche and Griguera Naon, determined that Colombia had nonetheless breached the minimum standard of treatment. This aspect of the decision emphasized that Colombia had been inconsistent by sending mixed signals to Eco Oro about the viability of its project, failing to ensure a stable business environment. And the tribunal described the situation as one of, quote, arbitrary vacillation and inaction with respect to the delimitation of the wetland. So the case is a little bit unusual in that even in the absence of a breach of the FTA by the host state, compensation was determined to be owed to the investor. However, in this case, the decision to compensate the investor, even in the absence of a liability, was to some extent taken in light of the express language of the treaty. And what I mean by that is that the Colombian Canada-Colombia FTA provides in some parts that it explicitly mentions that no compensation will be payable in the absence of finding of liability for those other provisions. That similar language was not included with respect to the general exceptions provisions that Colombia was seeking to rely upon. And so can be excused by reasoning to say, well, okay, fine, there was no clear exception with respect to liability in regards to this clause. And therefore, it can be viewed as an intention of the part of the states to have compensation awarded, even when the measures at issue related to the environment, provided that there was some other basis of liability.
Kabir, can I jump in? So I think this case is fascinating, and you could do a whole day on this case, Kabir. But you know, it was messy, this process. There were multiple government entities involved, you know, required to give different sign-offs and licenses, and it was a messy process. And that's what led to these ambiguities and mixed signals that, you know, a majority of the tribunal found held the state liable. But what struck me is, while it was messy, these sorts of decisions, particularly in, you know, somewhat open societies, that's the way it happens. And some people are arguing, oh no, it's good for the economy, it's good for jobs, it's good for, and it is messy. And so if I don't think there was any allegation that the Colombian government was not acting in good faith or was hiding the ball. It just was a bit of a mess. And, you know, it's going to play out like that, you know, particularly I think with the trade-offs involving climate change in the future. There's going to be lots and lots of disputes where you could point to mixed signals, things said in the press versus what's, you know, being said in meetings between the investor and the government. And so the system has to be able to deal with this. And whether or not it was the right decision here, you know, really turns on the language of the treaty, and we can't make some broad generalization, but it is a problem that is going to come up again and again, particularly with climate change induced disputes. So it's something that we need to think hard about and see if we can, you know, the bit that I mentioned and that Christophe mentioned earlier in our presentations, that bit probably would have obviated this dispute. So word to the wise there.
That's actually, Matthew, Christophe, that's awesome. I mean, just as a framing issue or an issue for us to think about, because I look at the Keystone Pipeline dispute in the US, 3 precedents, 3 very different approaches, affirming, denying, a series of presidential permits, and it remains to be seen what legacy NAFTA is going to tell us, what deference tribunals are going to give the United States in comparison to, say, what they did to Colombia. Noting, of course, as you all have spoken about, the differences that we see in treaties. So I think that's an exciting thing for us all to stay tuned for. You know, we have to see also what implication that has for us as US taxpayers, but we put a pin in that at least for the time being. But I invite everyone to give a round of applause to this awesome panel. I don't know where an hour and a half went. I think I could be with all of you all day, all night talking about these issues. Thank you so much. I see Simon has appeared on my screen, and that's a troubling sign. It's an indication for me to stop talking. Simon, message received. Take it over, Simon.
So thank you very much, Kabir. As you all know, we have reached the end. On behalf of the CAD organizing team, I would like to thank our 3 wonderful panelists, Yasmine, Christophe, and Matthew, for this very lively and interesting debate, and also our very skilled and funny moderator, Kabir. As we've glimpsed from the panelists' discussion and from the poll at the beginning, environmental issues are very closely linked to the issue of legitimacy and the ongoing reform process. And the good news is that this ISDS reform process is precisely the topic that our 4 panel will cover in 15 minutes after a well-deserved coffee break for everyone. So stay tuned and see you in 15 minutes for panel 4.
Bye, everybody. Thank you so much. Thank you.